Family mediation is a voluntary process where a neutral third party, a mediator, helps you to discuss and resolve issues relating to separation. These might include child arrangements, financial matters, or any other concerns that arise from your separation. Conversations in mediation are confidential and what we call without prejudice, meaning that they can't be used in court except for financial disclosure, which is always provided openly. This safe environment helps you to explore options and reach agreements with more freedom. Hello, I'm Victoria, a partner and mediator within the family team at Anthony Gold Solicitors. In this video, I'll guide you through the family mediation process, what it involves, how it works, and how it could support you and your family. What is the role of a mediator? A mediator is independent and impartial. Their role is not to give legal advice or take sides, but to facilitate discussions, help you reach mutually acceptable solutions. And they may also provide legal information to support the conversation. Independent legal advice is encouraged between sessions, and in some cases, hybrid mediation involving solicitors is also possible. What is a MIAM? Well, a MIAM, or Mediation Information and Assessment Meeting, is your individual meeting with the mediator. It's an opportunity for the mediator to learn more about your situation and your priorities, to discuss how mediation works, and to assess whether it's suitable, including any safeguarding concerns. They'll also explore alternative, non-court options with you, and it's your chance to ask any questions and understand the path ahead. What happens after a MIAM? If both parties attend their MIAMs and agree to proceed, you'll receive and sign an agreement to mediate, and the first joint session will be scheduled. If only one person has made contact, the mediator will then invite the other person to attend a MIAM. Mediation is entirely voluntary. Both individuals must consent before it can begin. If, for whatever reason, mediation is unsuitable or breaks down, the mediator can sign the court form required to start court proceedings. But remember, attending a MIAM is a legal requirement before applying to court, unless an exemption applies. What can I use mediation for? Mediation is flexible. You can use it to discuss child arrangements, finances and property, and both specific or narrow issues, as well as adjustments to previous agreements. Also, other professionals, for example, financial advisors or therapists, can be involved if it would be helpful. How many sessions will I need? Every case is different, but typically between 3 to 5 sessions are needed. Each session lasts 1 to 2 hours, and the pace is tailored to your needs and circumstances. Do we need to be in the same room? Not at all. Sessions can either take place in person or remotely via video, and in the same room, as well as separate rooms both physically or virtually. This will all be discussed during your MIAMs and adjusted during the process if necessary. For example, you could start in separate rooms and then move to the same room, or vice versa. Mediation is completely flexible. How much does mediation cost? Mediation is usually far more cost effective than going to court. Fees are often shared equally between you, and the total cost will depend on the number of sessions that you have and the individual fees charged by the mediator. What happens after we reach an agreement? Once proposals are reached, the mediator will provide you with a written record of any proposals reached. However, these will still be without prejudice and do not constitute a legally binding agreement unless both you and the other person wish to formalise this outside of the mediation process. For financial agreements, the mediator will draw up what's called a memorandum of understanding, and for child arrangements, a parenting plan can be created. Financial disclosure is also summarised in an open financial summary. These documents can then be taken to your solicitor to formalise legally if you choose to do so. Where can I learn more about mediation? For more information, visit our website for guides and resources. Do check out Resolution and Advice Now for additional support. And of course, you're very welcome to contact me directly. Call 0207 940 4000 or feel free to drop me an email on vgb@anthonygold.co.uk. I hope this guide has helped you feel more confident about the family mediation process. At Anthony Gold, we're here to support you every step of the way. Thank you for watching.